councils have demonstrated time and time again, they do not have the first understanding of the laws around strip clubs. Welcome to our mini webinar series on strip clubs. This time, we are talking about the law. So looking first at strip club policy. So policy should state what types of location might be inappropriate for a strip club. This could include being near churches or schools or women's refuges or universities, for instance. And we know of strip clubs that operate near all of these, including even on university campuses. You can create a zero policy. That means no location is appropriate anywhere in the borough. Policies must be created afresh. In other words, they cannot be written around existing clubs. Now, this might sound self-evident, but we are finding time and time again that that is exactly what councils are doing. You also cannot treat existing clubs differently from any new possible club that might set up. And you cannot exempt existing clubs from your policy. This again might sound absolutely self-evident, but we are finding time and time again that that is exactly what councils are doing. So for instance, you cannot have a zero policy that this says there is no location that is appropriate for a strip club, except for the current clubs. They can stay exactly where they are. You simply cannot do that. So to look at licensing hearings, again, councils seem to have no understanding that they have sweeping powers not to license or relicense strip clubs. And they have these sweeping powers due to location. So if a strip club is or might set up in an inappropriate location, they have wide-ranging powers to refuse it or to refuse to relicense it. And for clubs that already exist, they still have these powers. They do not have to show that there's been any change in location whatsoever. There do not have to have been any material changes of any sort whatsoever. They do not need any evidence of harm or anything else whatsoever in order to refuse the license. Again, councils seem to be wholly ignorant of this. They are not aware that they can refuse to relicense on the grounds of location. They do not understand that there doesn't have to be any change in location. They do not understand that there have to be no material changes whatsoever, and they constantly talk about needing evidence. You don't need any of this. And what's more, clubs cannot challenge this. They cannot legally challenge it. If councils refuse to relicense them on the grounds of location, a strip club cannot challenge this. They can try. They'll have to go to the High Court, which is extremely difficult to do. Strip clubs that have tried this have never won. They've never been successful. Most of the time, the judges chuck out the case before it goes anywhere. Despite this, we are hearing time and time again this sort of thing. This is from a former Sheffield councillor. So he said, our legal advice as councillors was always that if we refused to renew the licence, it would be challenged and we would lose. That is absolutely incorrect if they refuse the licence on the grounds of inappropriate location. So as you can imagine, Sheffield is one of many, many councils that has written unlawful policies and is making unlawful licensing decisions under those policies. And this includes councils like Leeds, Camden, Portsmouth, Blackpool, Tower Hamlets. They have zero policies that say there should be no strip club anywhere. There is no location that is appropriate for a strip club. And yet within their policy, they exempt all existing clubs. You simply cannot do that. We have Sheffield and Newcastle. What's interesting about them is that their policies are unlawful according to equality law. So Newcastle's policy states that equality law is actually irrelevant. It's irrelevant to their 8 strip clubs. Equality law couldn't be more relevant. Sheffield has been taken to court 2 times and been shown to be breaching equality law because of both its policy and its licensing decisions. So this takes me on to legal challenges. Ironically, Councils shouldn't be afraid of strip clubs issuing legal challenges. They should be afraid of the local community because they're the ones who do have a legal leg to stand on. So what we've seen in Sheffield now is 2 successful High Court challenges, with a third given leave to proceed. And the only reason it didn't go ahead is because the club in question, Spearmint Rhino, shut up shop, it sold and gave up. These have come at huge cost, financially and PR cost to the council. So they've been challenged both on the grounds of inappropriate policy and on the grounds of inappropriate licensing decisions. On both occasions, they were found to be breaching equality law, but was considering objections based on the very considerable harm of the industry as moralistic and therefore irrelevant, which you cannot do. This is a quote from Louise Whitfield. She was the lead solicitor in the Sheffield High Court challenge. And she says, a local authority must look long and hard at the adverse impact on gender equality of letting such an enterprise exist at all. Otherwise, it will be acting unlawfully and will be subject to legal challenge. Another way councils are subject to legal challenge is because they have a totally inadequate equality impact assessment. Some have none. Some have a tick box exercise, which you cannot do. As I've already mentioned, another way councils are subject to legal challenge is because they are constantly misinterpreting the legislation around strip clubs or SEV legislation. So councils are breaching both SEV and equality law in countless ways and countless times. And these are just some of the examples. So very often councils are not giving the correct grounds for even objecting to strip clubs. They don't tell people that you can object on the ground of locality. This is totally against SEV legislation guidelines, which clearly state you must clearly lay out the grounds on which members of the public can object. Some councils, like Camden, are even giving out people the names and addresses to strip club operators, which is again written in as illegal into SEV legislation and is, of course, a severe safeguarding issue and a breach of data protection. One has to question who is training counsellors, because it appears they get training from the lawyers, the barristers and solicitors who represent strip clubs. And yet we and many others have witnessed the total misdirection by strip club lawyers at licensing hearings about the most basic elements of the law. They are constantly suggesting to councils that the locality isn't relevant, there has to be a change in the locality, or that they need evidence in order to refuse a strip club license. Some even refer to Afghanistan in trying to suggest that equality law is irrelevant to strip clubs. So we've compiled more information about strip clubs. There's a huge amount of information about strip clubs here on our website. We've also prepared a legal briefing, which goes through many of the issues I've talked about here. And we're happy to speak to councils and licensing officers at any time to make sure they finally get it right.